But let's turn to the federal regulation of insurance and the possibilities for that in light of AIG's collapse. Basically, what we've seen with the collapse of AIG is that insurance and financial services industry are very much intertwined these days. It really doesn't make sense to, in some ways, to think about insurance and financial services, banking and investments as separate anymore. So the question becomes, should the federal government step in to regulate the insurance industry? Turning to slide number 23, historically, the states have regulated insurance. Going back to 1869, when the U.S. Supreme Court ruled that issuing insurance is not subject to the Commerce Clause. That's a situation that continued to exist until 1944, when the Supreme Court reversed itself and said that, well, it seems pretty obvious now that insurance, in fact, is interstate and therefore can be regulated by federal laws, which resulted in a pushback by the state insurance regulators and the insurance companies who wanted to keep the current or the state insurance regulation regime in effect. And that resulted in 1945 in the McCarran-Ferguson Act, which states that, going to slide number 24, basically states that the states have the primary authority to regulate insurance, and that only if the federal government or Congress enacts a statute that specifically is intended to regulate the business of insurance will the federal statute have primacy over state statutes. So it reverses the normal preemption rules, which basically says that federal law preempts state law that covers the same subject matter. And in the case of insurance, state law preempts federal law on the subject of insurance unless the federal law specifically says it regulates insurance. So what we have is a situation where you've got basically 50 different state regulatory schemes broadly overseen by the National Association of Insurance Commissioners, which promulgate and promote uniform standards for insurance laws and regulations, but has no authority to enact or enforce them. So, for example, New York's insurance department only was able to oversee the AIG insurance companies that were actually domiciled in New York. And they had absolutely no authority to regulate credit default swaps and no ability to regulate credit default swaps, nor did any other state insurance commissioner. Now, turning to slide number 25, then, what we in 2007, the Treasury Department engaged in a comprehensive study of the regulatory structure in place for the financial services industry, including insurance. And this resulted in March 2008 the issuing their report called The Blueprint for a Modernized Financial Regulatory Structure. They concluded that the way that the financial services industry is currently regulated, being divided amongst different regulatory schemes for banking, for securities, for futures, for insurance, doesn't make any sense anymore. There's tremendous overlap. And specifically with respect to the regulation of insurance, the report concluded that the state-based regulatory system is not the most efficient or effective way to regulate the insurance industry. The Treasury Department was particularly concerned that there were gaps in the regulatory system that resulted by this sort of balkanization of the financial services industry, with, of course, credit default swaps being the poster child for that sort of regulatory gap. And what the Treasury Department has proposed is the creation of an optional federal charter system where insurance companies could opt into a system of federal chartering, licensing, regulating, and supervising of insurers, reinsurers, and insurance producers. They want to create an Office of National Insurance to create and oversee the regulatory, supervisory, enforcement, and rehabilitative powers of the system, and an Office of Insurance Oversight, which would basically be a policy advisory body to the Secretary of the Treasury. On slide 26, the response to the Treasury Department's proposal, which is basically a proposal for broad and comprehensive federal regulation of insurance, has been mixed. Not surprisingly, the National Association of Insurance Commissioners is not in favor of it. They point to the the financial strength of AIG's insurance subsidiaries as proof that the state regulatory scheme works. However, the National Association of Insurance Commissioners was created for the very purpose of addressing the need to coordinate regulation of multi-state insurers, and one of its primary goals is the development of uniform policy when uniformity is appropriate. To the extent that the NAIC has been successful in that regard, and to the extent that, if anything, the need for uniformity in the modern insurance environment has increased, where we have every insurance company that is of any size is national in scope, if not multinational or international in scope. The existence of the NAIC itself is an argument in favor of really comprehensive national regulation, the difference being that with federal regulation, you would not only have the ability to promulgate rules, you could also enforce them. And so we have organizations like the American Insurance Association and the Risk and Insurance Management Society who have come out in favor of the optional federal charter system proposed by the Treasury Department. And currently there are several bills before Congress to enact some or all of the OFC approach. And on slide 27, you'll see that, if anything, the push towards federal regulation has probably been enhanced in recent months, especially with Secretary Geithner's recent testimony before Congress advocating comprehensive reform of the financial system, including insurance, and stating that new rules of the game are necessary.